This wasn't just another courtroom moment. A father stood accused of choosing alcohol over his own children. Freezing night, kids left outside. No excuses, no sympathy. The judge didn't hesitate. Custody stripped, control gone. Some mistakes don't deserve a second chance.
He had previously had a drug problem. He went through rehab a number of times through the marriage. Then he professed to be clean, but was doing the kratom and the Delta 9 and then reverted to just alcohol. So Mr. Kurt Vandervoort represented him during the pendency of the divorce, and there were some other issues. So we went through a process where he used a ankle monitor, an alcohol ankle monitor for a period of time to stay sober and to stay clean. He successfully did that, and we ended up resolving the case back in October, where Mrs. Hedgepath was designated as the primary residential parent, but there were specific requirements set forth in the parenting plan. It was a graduated scenario, as long as after he successfully completed the interlock device and the alcohol suppression, the ankle monitor scenario. But we put provisions in there that it was specifically the father was not to drink alcohol before or during his residential time. He was not to use non-prescription medication, mild altering substances, including and not limited to, as I say, gas station or drugstore drugs and substances. Specifically, Judge, we put in the mushrooms, microdosing mushrooms, and any other illegal substance. The mother had the right to request an extended panel hair follicle test. She had the right to have a breathalyzer performed. And so he did good for approximately a month to a month and a half, and then reverted back, wherein he was allowing other people around the children who were intoxicated. He became intoxicated with the children. In fact, over the holiday, an event occurred, and he put the children outside in virtually freezing temperatures and told her to come get them. We filed a restraining order, and we came before this court on on February 11th for an extension of the ex parte restraining order. Mr. Hedgepath appeared. Mr. Hedgepath was placed under oath. I questioned him. He admitted that he was drinking during his residential time with the children. As it said in the court finding in the sworn testimony of both the petitioner and the respondent, that due to the respondent's drinking during his residential time with the children and other circumstances occurred, it was the best interest to modify his residential time pending a hearing where he only got residential time at the mother's discretion. She has allowed residential time when she is ensured that he is not drinking or subjecting the children to inappropriate individuals. There was a domestic disturbance at his home at one point in time where a gun was pulled and then the person that he had living there and was partying with was arrested. I think he's still in the jail here. But when Mr. Hedgepath came to court, I questioned him about that. He readily admitted all of that. And he admitted that he understood he had an alcohol problem, but he had no intention of stop drinking. He was just not going to do it around kids. He was given an opportunity to file a responsive pleading. All of that was testified to, and we're here now to move for a default judgment.
All right. You want to put your client under oath, and
yes,
you'll raise your right hand, please.
You're Misty Hedgepath, is that correct?
It'd be simpler if you just said ditto to whatever she just said, I suppose, but we need you to testify under oath about what's happened.
So Ms. Hedgepath, you've heard what I had articulated to the court of what transpired after the divorce. He had an ankle monitor, and he did not violate and drink alcohol, do anything to your knowledge during that time. And then immediately after he got off, he reverted back to his old ways of alcohol and becoming intoxicated. We're not aware, haven't wasted the money to go do a 12 panel because he's admitted that he's drinking. He came before the court and admitted that he had violated the court order. Additionally, during this period of time, he was already adjudged being behind in his child support some $5,700. He was supposed to make a payment of $1,900 at the end of December. He failed to do that. He paid $1,000, but did not do it. He is also supposed to pay, I think today, $1,900. And then he has not paid any child support for January, February, or March. Is that correct? And based on the agreement we had with his attorney, his child support was set at $950, but he was to pay $200 towards daycare and $146 towards his portion of insurance. And he's failed to pay those payments. Is that correct? So as we stand here today, he's admitted before the court that he's violated the alcohol ban. He has failed to pay one payment to satisfy his past due child support. And then he has failed to pay child support and has a new arrearage of $3,888, which is the 3 months of the $950, the $200 daycare, and the $146 for insurance. Is that correct? In addition to that, he has made significant inappropriate statements to you and the children, threatening that your oldest son will be 12, I think, next year. Is that correct? Or this November, and that he's just going to get him and he's going to come live with him. He stated he has no intention to quit drinking. And you're in fear of your children's safety. What led us to go and to get the restraining order was over the children's Christmas break. He had gotten into an argument with a paramour. Your son was having some significant difficulties not sleeping, and he became enraged, called you, set the kids out on the steps in cold, freezing weather, and said, "Come get them." And you had been, what time of night was that? 11:30. And he was supposed to keep them kind of for another. He couldn't stand it. He couldn't tolerate it. He just lost it. You believe he poses a danger to your children?
I know that he loves them, but I don't think he's able to take care of them the way he should.
And again, your parents have supported you, and in fact, his parents have also see it. If he's made threats against your father's life and against his own father's life when they try to come in and to offer fatherly advice. Is that correct? You believe a modification of the parenting plan is in order. You want to be your primary parent, and you want to do that, but you want to limit any residential time that he has to be at your discretion. You understand your kids, again, love their father, and that you want him to have a relationship with him, but you want it to be a safe relationship. And you're at this point in time able to manage that with the court order saying when, where.
Yes, I have been, I've breathalyzed him before and after his time with him, and I don't allow overnight.
And you've been able, I think you just even let him have some time this weekend.
I did. Since sport, I've let him see them at least once a week, for several hours, like 3 hours. But I make sure that the breathalyzer is 0.00 before he takes them, and then he blows in it afterwards too. The only way I know it.
Right. And you understand that's your cross to bear at this point in time. Is that correct? Mm-hmm. And so you're wanting to modify that residential schedule. Additionally, you want to claim all the children as on the tax purposes before we had negotiated, because he was supposed to pay child support, but he's utterly failed in that endeavor. Is that correct? And you're also wanting to put in the provision, excuse me, that recalculate the support for 365 days to use 0 to him. And again, daycare expenses, it's $200 during the school year, but it will go up a little bit, and we're going to average those costs. You're going to get me those, and we're going to average those costs. And you're keeping health insurance, and we're going to include that. Neither one of you have any other children or any other credits that are entitled in the child support. And using your income that we just did, and when we calculated it, and his should be appropriate. And you believe that's correct? And you've incurred attorney's fees in this in the amount of $5,000, and you're asking for a judgment for that. Is that correct? That's our proof, Your Honor.
All right. Based on the proof before the court, and the court grants the default judgment and also grants the relief sought in the petition, which is to modify the parenting plan to designate her as the sole person in charge of his visitation with the minor children. It'll be at her discretion. I will order that the child support be recalculated according to 0 days for him and 365 for her. In addition to that, she will be the sole person to claim the children for taxes, and she will be awarded her attorney's fees and court costs.
Thank you, Your Honor.